All right. Again, can you hear me on Zoom? And also, can you see the slide or at least the website? I know
Yeah.
people in class can see it, but I'm talking about the ones on Zoom. People on Zoom, can you see the website
Yes.
about disclosure?
Yes, Simon.
Okay, beautiful. All right, class participation, folks. Remember, when you're out there in the real world, you cannot stay silent, right? So again, thank you. Good morning and happy Friday, August 22nd already. We just got a few more days to the end of August, and we're in the transition into September. Man, super fast, super quick. Things are happening, and before you know it, we're at the end of the year. We're going to be discussing uh, disclosures, okay, and the importance of what we do as real estate professionals, right? And it really doesn't matter if you represent the seller or if you represent the buyer, right? Part of the process is you're going to exchange. If you're working with the listing agent, as an example, excuse me, if you're working with the sellers as a listing agent, as an example, you're going to be sitting down and discussing all of the relevant information about the property, the condition, any known material facts about the property that is relevant, that should be incorporated and ultimately provided as part of the seller disclosures. Now, this is where sellers get themselves in trouble. This is where sellers get into issues, and sometimes it escalates to a potential lawsuits because the buyer feels that the seller was not truthful in the condition of the property or anything that was not provided as part of the process. And in the situation, most lawsuits happen from a buyer suing the seller. Okay. So I want to have a really candid conversation today about the resources that we have, especially for the newer agents on the call. You know, you're still in the beginning stages of understanding every process. Now, on the flip side to it, right, when you represent the buyer now, your job as a real estate agent is to really sit down and go through all of the elements of the seller disclosures, because the buyer has to make an executive decision if they're going to either ask for any type of repairs, do additional inspections, or ask for a price reduction, credit in lieu of repairs, or they just decide to back out of the deal because of what they see from a seller's point of view. And again, this gives you a perspective to navigate this process, right? And more so, as you're going, this is where most deals fall apart, is through this period. Within 7 to 14 days, 17 days is where we see a lot of transactions fall apart because of seller disclosures. Now, if you're a member of the local association, they got a lot of classes in regards to disclosures. But the California Association of Realtors also has, you know, some resources where you can also dive in. So one, I wanted to share before I actually go through some of the more core forms like your TDS, your SPQ. I wanted to share this site here, and this site goes into all about disclosures, right? This is through the California Association of Realtors. All you have to do is type in on search menu seller disclosures or disclosures in general, okay? And that'll take you to this site here, okay? That'll take you to this site. All about disclosures. It's a curriculum, right? And the curriculum is preparing for the stringent disclosure requirements. Disclosures are one of the most important areas to understand in real estate today. All sellers are required to disclose material facts, right? as a real estate agent, you have to have a thorough knowledge of the California real estate disclosures. And all about disclosures, the course you will review approximately 30 disclosures that are typically seen in a residential of 1 to 4 units, guys. Yeah, that's a lot. That is a lot. The course will help you understand the reason behind the disclosures, when the disclosures must be made, and when they might be exempt, right? Because there is some exemptions to certain properties. Taking the course can give you a better understanding on how the process works. Now, I wanted to just share this with you because I think it's pretty relevant. You can take it online anytime, or you can do live or learn by my way, right? What are the benefits? Here are the benefits. Okay. Understanding how to complete disclosures, learn how to read and use the various disclosure charts, review some important and recent cases affecting disclosures, discover local ordinance disclosure rules, review miscellaneous issues such as disclosures of repairs, death on the property, and illegal and contractor disclosures. Okay, the course covers the definitions, history of disclosures, the basics of requirements from 1 to 4 units, the agency disclosure, which is a lot of agents just don't understand that is a disclosure that you're giving both the buyer and the seller. And the big ones like the transfer disclosure, right? The TDS, an exemption. When do you use an exemption to the TDS? Smoke detectors, heater bracing, carbon monoxide, the list goes on and on and on and on and on, right? So just kind of giving you a parameter. A lot is also registered as a sex offender, right? There's a language on the SPQ where someone wants to know of any registered sex offenders near or around the property. How do they get that information? That's all part of disclosures. Death of an occupant, right? When and what's the timeline when you have to disclose to a potential buyer that someone has passed away on the properties, the do's and don'ts, right? But more so, what if the person passed away not in the property, but inside the complex, right? Or inside the lot? Is that still considered part of the disclosures, right? They might have passed away in the backyard, in the front yard, on the side of the house, right? How do we approach and how do we navigate that, right? The contractor disclosures, the advantages of having very efficient disclosures, right? So again, I wanted to just share this resource through the California Association of Realtors that we have extended training that you can take. Now, not 100% sure if this is a cost or if it is a cost. So the cost is for members is $79. Non-members is $158. But again, I'm a true believer that the more knowledge that you have, the better educated that you will be in how you articulate the conversations with your sellers and with your buyers. And the issues that we see quite often too when working with investors, and what they've done to the property too, that's part of material fact too, and how you navigate those conversations when they now are ready to sell the property, right? And part of the stipulation that I truly believe is I'd rather disclose everything, expose everything that has been done to the property or I'm aware of what has happened than to avoid a potential liability a few months later after we close or even a year later. It comes back to haunt us, right? Because we failed to provide that. And guess what? Because we were involved in the transaction, we may be entangled and dragged into a potential lawsuit. So this is why it's very important and vital for all of you to understand every element and how to navigate these documents. Okay. You can save it, you can email it, and all that fun stuff. So I wanted to just quickly share this information. All right, so let's dive into what's the most relevant as you're navigating your real estate transactions, right? So when you go into your transaction hub, right, secure, you go into your zip forms, you log in. Once it confirms, okay, now you're in the forms as an example. I'm going to just click on this quick file here. And here's all of your, oops, it doesn't look like on Zoom. Is it still loading on Zoom, guys?
Yeah, it's still loading.
Okay, that is weird because it shows on my end. Okay, let me stop sharing. Let me share once again. Let me click on here. Okay, let's see if now it comes up. There we go. Perfect. All right. So here is where all of your forms are at, right? When you're navigating, it doesn't matter again who you represent, if you represent the seller or the buyer, this is where all of your information is gathered, right? So I want to dive into the SPQ. Okay. Let's see here. SPQ. I'm trying to toggle two computers at the same time, so I apologize for the delay here. So here is one of the seller disclosures, and it says seller property questionnaire. You want to make sure you have the most updated information, which is December of 2024. And it goes into really the elements of who, as a seller, questionnaires that are relevant to a process when exchanging real estate from one person to the other. Okay, it's no difference in selling a vehicle. And part of the process is, look, the buyer can do what they need to do, check the engine, check the transmission, take it for a test drive, check the steering, check the tires, look at the body of the vehicle, before they make a decision to move forward with the purchase, right? Well, this is again part of the process for a seller as well. The seller has to provide all of these documents with a certain period of time. So once we have an acceptance, that starts the timelines of events that need to happen. Contingency removals, right? Loan process, appraisal, and buyer's inspections if it's part of the agreement, right? So with that is how do you navigate the forms itself? Well, if you are the listing agent, you want to have these documents already filled out before you even are in escrow. This is why spending some time with the sellers and sitting down and really anchoring the position. Now, I also want to stress and emphasize the importance that we as real estate agents do not fill out these disclosures. This is seller's responsibility. Even if they ask you to help, you can guide them, but they are the ones that need to ultimately fill these out, right? Because you don't want to entangle yourself and catch yourself in a situation where now you are liable because of what you put there. Okay, so don't do it. Now, the SPQ has a lot of information, lots of information. Okay, you can see that it has a lot of questions. It can be a little overwhelming, too overwhelming sometimes. The question sometimes that I hear from agent is they don't know how to fill this out. or they don't know if this is relevant, right? If it's a question that gets brought up by a seller, then it may be relevant because they're thinking about this question. Now they're just trying to put the puzzle together. Okay. A lot of information. Now, again, let's go through the motions of what this form really is about. It says that this form is not a substitute to the TDS. Okay. It's not a substitute to the TDS. What it is used by the seller to provide additional information when the transfer disclosure statement is completed. If seller is exempt from completing the TDS, seller shall complete an exempt seller disclosure, better known as CAR Form ESD, or may use this form instead. And it says, note to the seller, you are strongly advised to carefully review the Disclosures Information Advisory, CAR Form DIA, before you complete the seller property questionnaire. All sellers of the California real estate property are required to provide various disclosures, either by contract or by statute or case law. Many disclosures must be made with certain time limits. Timely and thorough disclosures help to reduce disputes and facilitate a smoother sales process. And it's so true, very true. The more information you give to the buyer, the less liability that the buyer can come back and say about you failed to provide us with any concerns that we should have been known of. Well, this is why we send all of these seller disclosures for that purpose. Now the buyer cannot come back and say that we failed to provide a issue regarding the property. Well, this is why we go back to these documents and reference what was said. Because the truth of the matter is, once the deal closes, we close this file. It may take months. You're going to forget what transpired through the process. This is why you can now go back and see what actually did happen with the process. Now, pretty self-explanatory. It goes into, the description of the property, in this case, Santa Fe Springs and Riverside, city of Hemet. If it is a property, is a duplex, triplex, or fourplex, a SPQ is required for all units. This SPQ is for all units or only one or two. So you can use this one form for all 4 units as an example. Unit 1, Unit 2, Unit 3, Unit 4, A, B, C, or D, whatever. Or you can select specifics. Maybe 2 are included, and then you add a second SPQ for the remainder 2 on a 4-unit multifamily apartment complex as an example. But for the sake of today, we're going to say that this is a single family residence, so it's only going to be one property. Now, one goes into a disclaimer, right? And that disclaimer says limitations. The following are representations made by the seller and are not the representation of the agent. If any, the disclosure statement is not a warrant of any kind by the seller or the agent. It is not a substitute for any inspections or warranties the principals may wish to obtain. This disclosure is not intended to be part of the contract between the buyer and seller unless otherwise specified in writing, and broker in any real estate license or any other person working with or through broker has not verified information provided by the seller. A real estate broker is qualified to advise on real estate transaction. If seller or buyer desire legal advice, they should consult an attorney. Number 2 goes into note to the seller. The purpose to tell the buyer is about known material or significant items affecting the value or desirability of the property. I want to stress on that language, because that language has been in conversations in many years that I've been doing this, that's your escape clause, in my opinion. Okay. And the reason I say that is because when you're having a conversation with either party, you're trying to explain to the parties the reason why it's so important for you as a seller to do a thorough understanding of what these forms really entail to protect you from any future liability. That's what it is. So in essence, I say, look, you're just protecting yourself, but you're also providing the buyer with any known significant issues that we must disclose. So think really hard, Mr. and Mrs. Seller, what that is, because I want to make sure that this doesn't come back and haunt us because we knew something and we failed. And when I mean I mean the sellers, right? You knew something and that you failed. And guess who is the biggest advocate when it comes to, hey, by the way, did you know that this happened in the property? It's your next door neighbors. They're the biggest one, your neighbors. So be careful, okay? Because this can come back and haunt us. And if we covered all bases, then we're good. Now, if you don't know, you don't know. And I get it. There's things that you don't know. You don't know what's inside the drywall in this training room, right? It's not like the seller is going to make holes and see, okay, I see that there's some issues. No. But if there's some concerns or something that was done to the property, it's just best to disclose. Best to disclose. But I like this language that says about material significant affecting the value and desirability. So when you think about it, how can this affect the value in the future and the desirability, right? To stay in the property, right? Because if those two elements do come up, they can use that against us, and that opens up an opportunity for the buyer to be awarded monetary compensation because the seller failed to provide any known material fact about the property, significant issues with the property that may impact, again, what? The value and desirability of the property. The property to help eliminate misunderstandings about the condition of the property. Answer based on actual knowledge and recollection at this time. Sometimes you do not consider material significant may be perceived differently by the buyer. I love that because what you interpret may be interpreted differently by the buyer. So think about that for a minute when you're having the conversation with the sellers on the importance. Well, I don't think that's really relevant to say about this particular issue when we turn on the bathroom shower and makes this sound like it echoes on the other side of the hallway. You know, we got accustomed, we got used to it. We've been here for 30 years. Sometimes I don't even hear it anymore, but in the beginning I did hear it, but I never really put emphasis to really explore what that sound was, right? And because it may not be relevant to the seller, they're selling the property. They don't think it should be put on there. They may skip it. Well, thank goodness that you hired a real estate agent. I think that is significant. I think that is something that we must provide as part of that so the buyer can do their due diligence. Because let's say that the buyer is a plumber, right? And they're going to know, I've seen that situation. So then they know how to navigate, and now we fully disclose the issue. And it may be something of a fix, or it may be something significant, right? Now we can use that as negotiation. I, as a buyer, want to know any knocking sounds coming from another side when you turn on the shower, right? I think it's relevant. I think it's very important. Think about what you would want to know if you were the buyer, right? Always emphasize, listen, put yourself Put yourself as a buyer. Wouldn't you want to know anything and everything about this home before you make a sound decision to move forward with the purchase of the property? Especially on a very high price point of, 500 plus, a million plus, 2 million plus. Absolutely. Because the bigger the home, the bigger the checks you're going to be writing, right? So I think it's very relevant. So when we're having a conversation, I would say, well, put yourself in the buyer. If you were the buyer buying your property, which you probably will once you sell your home, you're going to be that buyer. How would you feel? I think you want to know, right? I think it's something we should know. Now it goes into talking about, read the questions carefully and take your time, right? This is why when you go on a listing appointment, you have a listing agreement, start working on this with the sellers immediately before it even goes active, because you don't want to be at the last minute providing these disclosures, because one thing is, you have an obligation, the seller has an obligation. Once you get an acceptance, you have to provide these documents at a certain period of time, which is not that much. I think it's 5 or 7 days from the time of acceptance to provide all seller disclosures. Your TC needs to be on top of it too, because anything that is delayed and not provided to the buyer, right? They can use that now to do additional inspections, and they get an additional 5 days to inspect, and ultimately a decision, if they feel that it's going to be more than what they thought, to back out of the deal, even if they release physical inspection contingency. So be very, very careful. So be proactive, give all of the disclosures in a timely manner, so that way now you can push. We provided you with all the disclosures, you reviewed them, you acknowledge them, you approve them, send them back, and you can now release that as part of the condition, so that way you can now continue moving forward with the process of closing the deal. Okay. Now, it also says here, if you do not understand how to answer a question or what a disclosure or how to make a disclosure in response to a question, whether on this form or on the TDS, you should consult with who? Yeah. Are we attorneys? We are not attorneys. We are not attorneys. So we must always revert them back to, please speak with an attorney to guide you through the steps, right? Because then our hands are clear, right? There's no issues whatsoever. Okay. So I think it's very, very important to always consult with an attorney. A broker cannot answer the questions for you or advise you on any legal sufficiencies of the answers or disclosures you provide. And it also now reverts to the buyer. Note to the buyer, purpose to give you information about any known material or significant items affecting the value or desirability of the property, and to help eliminating any misunderstandings about the condition of the property. So it's a twofold question, right? It's a question that goes directly to the seller, hey, your importance of disclosures, but also to the buyer, hey, this is also for you and your protection, that you should also read these documents and make sure you understand these documents, right? So you can make a sound judgment if it's something that you want to negotiate or you're okay to move forward with it, right? Then it goes into seller awareness. For each statement below, answer the questions, are you seller aware of? By checking either yes or no. A yes answer is appropriate, and no matter how long ago the item being asked about happened or was documented, unless otherwise specified. Explain any yes answered in the space provided, or attach additional comments and check paragraph 19. Okay, so I want to be very clear on this, because I get this quite often. Well, If the disclosure says that we must disclose when someone has passed away in the property in the last 3 years, and this person passed away, right, 10 years ago, on paper, do we need to disclose a death on the property? Okay. The answer is no, we don't. But let's say that the buyer's doing their inspections, they're on the property, they have the document, and now a direct question to you is asked to you, or possibly the seller, if the seller is there. Hey, has anyone died in the property? What would be your answer? Absolutely, because it's a direct question to you. Okay. But what if the buyer says, well, why didn't you disclose that? And your answer is because we're not obligated per the agreement here. And I'll share where that says. Okay. So anything within a certain period of time you disclose, but on a direct question, then yeah, it's relevant for you to say, yeah, someone passed away 10 years ago of natural causes, right? If a direct question is asked. That's only if a direct question is asked. You're not going to divulge that information if not asked, right? But if someone is asking you, it's perfectly fine, even though it may not be relevant to include it as part of the agreement. Okay. And it's always going to say, are you seller aware of? Okay. So this is where the seller needs to think, because I get this quite often. Well, the seller has not lived in the property. It's an investment property. I get it. But you still know issues about the property, right? When the tenant calls and says, hey, the sink is backing up, right? Or the plumbing is not working, right? Or the light is not turning on, right? You know all of these issues. You have to disclose, folks. It's better to disclose than not to disclose. It's just best. The concern that I hear a lot from sellers is, if we disclose, then they may not want to move forward with the sale. Well, remember one thing. All properties are sold in as is condition. Okay? As is condition. So in theory, I personally would ask the seller, look, tell us everything about the properties and document everything. So that way the buyer can make a sound judgment how they're going to proceed. And if they do ask for a request of repairs, you can negotiate that. Just because they throw a number doesn't necessarily mean you have to accept it. You as a seller can also do your due diligence and get estimates on how much that is going to cost to get it done. Maybe they're just going over the top in hopes that they get a number back. Do your job as well as the buyer's doing their job as well. Okay. All right. It starts off with documents. Okay. So if there's anything in relations to documents, the seller has to either put yes or no. And if it's a yes, then it also says to please put a explanation. Reports, inspections, disclosure of warranties, maintenance, recommendations, estimates, studies. I mean, it's very, very thorough. Okay. Number 6, statutory or contractual requirements are related. Here it is. Within the last 3 years, the death of an occupant of the property upon the property. Now, it says 3 years, the death of an occupant of the property. So let me ask you, because this is kind of vague. What if it wasn't an occupant that was living there? Someone was visiting or a guest or it happened at a party. I'll share a story. A good friend of mine's passed away. He had a massive heart attack at a Halloween party. He was having a good time and then collapsed. He didn't live in the property. He passed away in the property. They try to do CPR, not responsive. The ambulance eventually picked them up. But is that in your mind something that we have to disclose?
No, but I think it's better to, I don't know. Like, I think it's no, but because it says occupant clearly, but it's better to disclose it.
Well, and I'm throwing this as a scenario, right? Because one, the doctor hasn't confirmed the time of death. You're doing CPR on someone, right? But they're not being responsive. 911 has been called and the ambulance picks them up, or he or she, and they take them, right? But you know that he's gone, right? He's not going to make it. And then you get the news. You're the owner of the property. You're devastated that a friend or family or whoever passed away, right? And now a year from now, you decide to sell the property, and now you have to answer this question, right? How would you respond to that? I know some of us say, well, no, it was an occupant. Some of us may say, well, it's considered material fact, right? Because remember, what did I say earlier? Who's probably going to know? The neighbors. Hey, by the way, last year in Halloween, one of the family members passed away on the property, because it's like this. I can put 5 people right in front and I can whisper one thing to them, and they whisper to the end. By the end of that conversation, it's going to be completely different. Yeah, right. So the neighbors are probably going to say, now for me, it's kind of a toss and turn, right? Because it's very specific of what it's asking here, right? It says within the last 3 years, death of an occupant on the property upon the property. Okay, an occupant. Now, occupant is very convoluted in my opinion. I could be an occupant in here. I'm occupying the place right now, right? I'm sitting here as an occupant, right? And then I pass away. I can see it that perspective too, right? It's best to disclose than not disclose. But it also says that the manner of death may be material fact to the buyer and should be disclosed except for a death by HIV or AIDS. Okay, that we don't, it's a protected class. Okay.
With the exception of if asked directly, then you answer directly.
100%. If I ask Steve, well, how did the person pass away? What was the reason, right? Then that's a direct question. Then we're not exempt to not divulge that information. We have to. Unfortunately, the person did pass away of AIDS or HIV.
Simon, just to follow up on what Steve said, what if someone asks us directly if a crime happened on the property?
Okay.
That's so true.
So you're asking if a crime occurred on the property, right?
Such as murder.
Yes.
Yeah, you have to answer it as truthful as you were given that information, meaning the seller. If a crime happened, I would disclose.
Like a break-in, for example. So we can disclose that if we're asked about the property.
I think there's a section in here that says if there's any other relevant information that you feel will be compelled for the buyer to know, then yes, I would. Because again, going back to the neighbors, did you know that this house has been broken in 5 times?
It would have to be firsthand knowledge. Otherwise, it's inadmissible in a court of law. So you have to have been a witness to something, and it has to come from that individual directly. So they would have to be the witness, and you're talking to the direct witness. Otherwise, it's not admissible in court of law. It's called hearsay. And hearsay is really kind of meaningless because it goes through so many different ears that you're right. It's like playing that game of telephone in the back of the room, but by the time the conversation gets to the front, it's completely different. So it has to be from the person that witnessed it, that was there on site, It's kind of like that whole story with OJ and the limo driver, and the limo driver pulls up and he says, well, I heard they found a glove on the side of the house. Well, he was not a witness to that, so they throw that out.
Okay. All right, everyone has their own personal perspective, and I appreciate you, okay? But what is the first thing the seller's gonna do when they know they were broken in?
Call the police.
Yeah, they're gonna call the police, they're gonna probably have an incident report, and that was documented, right? But what if they have cameras too? A lot of homeowners have surveillance cameras, right? And the surveillance camera sees that an individual goes in there, breaks or kicks the door, comes out, and they have a bag full of stuff, right? That is not considered hearsay, right? It's factual stuff. So in essence, look, not to go too crazy or too intense in the conversation, you know, again, I know it's probably something that the seller's thinking, well, if I put that there was 5 break-ins into my house, you know, no one's gonna wanna buy this property. Maybe the case, but maybe there's someone that doesn't really care and they'll still want to buy the property, right? I'd rather go in the direction of disclosing because it's gonna cost you more money that you don't disclose and you knew about it, you failed to provide that to the buyer. Remember, because the problem here is it goes back to desirability in the value, right, of the property. I wouldn't have bought this property and now I have to sell it and I have to sell it for less than what I bought it for. You as a seller may be responsible for the gap that they lost because you failed to disclose. That could be hundreds of thousands of dollars. And guess what? Attorneys are gonna push hard for a jury by trial. As the defendant, right, defending my case as a seller, as an example, I don't want to go to court because it's a coin toss. It's a 50-50 chance that I'll win. I might have a compelling argument in my position and witnesses and all of that, but the jury may see it differently. And if they see it differently, then the next step is, well, what is the amount of damage incur, right? Well, I had to sell it for a lot less to get out of this because I wouldn't have bought this property if I knew there was 5 break-ins. I'm in fear of my family. I have small children, you know? What if these people have weapons and all that when they break in when we're asleep? So many things. And guess what? The attorneys will twist it and will make it look worse than what it really is. That's where they hook and ultimately influence the people. I don't want to go in that rabbit hole, folks. Disclose, disclose, disclose. It's just best. Even if the seller takes a loss and sells it, but I can at least sleep okay that I did the right thing. That's what we're trying to explain.
Whenever I get the what about question, Steve, what about this, what about that? I can tell my sellers, you know, on the what about questions, disclose. And when in doubt, disclose.
Yeah.
You can't get in trouble for over disclosing.
That's right. That's right. Yeah, thank you. All right. I'm not going to go deep into all of this because we'll spend hours here, but I just want to go quickly because I still want to go into the TDS, okay? Repairs and alterations. This is where a lot of sellers get a little bit confused, especially investors, right? And it goes back to, are you seller aware of? Okay, that's in bold, that's in bold, and capitalized is explaining to the seller, hey, disclose anything you know about the property, right? And it says any alterations, modifications, replacements, improvements, remodel, material repairs on the property, include those resulting from home warranty claims. They're really thorough on these, okay? Now, I encourage you to read this and really get a base and an understanding of how you're going to explain this to the seller, because this is the seller's responsibility to answer yes or no. Don't have them just put no, no, no when they know there's some issues, because if it comes back, you look at it, it's like, oh gosh, they should have disclosed this. And they put no, that means that, one, they're hiding something, they're not being truthful, or they're just don't want to disclose that because it may be a bad thing and they may not want to buy the property. But that's also, again, why I say it's best to disclose and not be in a litigation. Okay. There was something here. Okay. So whether the property was built before 1978, if no, leave 1 and 2 blank. If yes, whether any renovations, sanding, cutting, demolitions of lead-based paint service. So all of this stuff is so relevant, folks. Okay, be very careful in how you're explaining this to the clients. Okay, but under no circumstances do you fill this out. This is your seller's responsibility. Structures and systems in place, disaster relief, okay, especially like in Texas, right? A lot of floods in Texas, right? It's unfortunate, but I'm telling you, they need to be aware, because if they buy a property knowing that they had a flood and they failed to disclose, and the buyer buys the property and now the property does flood, and now they come back to say, hey, this couldn't have been the first time this has happened. Big liability, in my opinion, big liability. Okay. Water related or mold issues, pets and animals. Okay. Let me ask you this question. I lived in the property for 30 years. I've had small kids, they've grown up. We've had pets. We've had pets throughout the years. Pets were puppies. Pets became adults. Pets die. And we used the backyard to have a pet cemetery. I know, because my parents' house, there's some pet cemetery back there. Full disclaimer, guys. Right? Would that be something that I would disclose if I'm selling the property?
When in doubt, disclose. So yes, absolutely.
100%, guys, because we don't know if the buyer is superstitious. There was a movie done many years ago called Pet Cemetery, right? I'm just saying, yeah, disclose. It's like, why is that even relevant? It's animals, right? For us, it is. It's a gray spot where, our pets that we love, unfortunately, people just feel that they want to bury their animals. I don't know. But yeah, if you're planning as a seller to sell that property years later, that's a relevant thing too to say. And I don't know if it goes into details about it, because the question here is, that's where I was going to go. On that section where it says in the last 3 years, right? Has anyone passed on the property? Is the animals considered?
Occupants.
Yeah, occupants. Yeah, thank you. Is that considered, a relevant disclosure to say that a pet has passed away within the last 3 years? Okay, because that may be a question asked by your sellers. They were like my child. Is that considered an occupant?
So was my goal.
Yeah, exactly. So, past or present pets on or in the property. Okay, it says past or present. Past or present problems with, yeah.
Even if you buried it, even if you had, Rover 20 years ago, and Rover's gone, yeah, and let's say you have a whole menagerie, according to the question, it needs to be answered.
Yeah. Yeah, it's a interesting conversation to have. It is. But people, when people move in, what do they do first thing? They start renovating, they start doing all this stuff. And what if they're doing some landscaping, right? So they start landscaping, or they plan to put a pool. And they start digging, and before you knew it, you see all these bunch of bones. It's like, what the heck? Something out of a poltergeist, right? wait a minute, were they doing some crazy stuff here? You know, people will think whatever, and that can open up a can of worms and liability. So in my opinion, fully disclose, right? Simon, that is so ridiculous that we have to include that. Yeah, but it's even worse when you know you have to go into a lawsuit and, you're now in a deposition and you're thinking, God, I should have just disclosed this. Okay.
Simon, just a question. If something happens after you submit the disclosures and before close of escrow, is there an additional form where you put the addendum, like, is there an addendum for this, or you have to refill the whole thing?
Yes.
Double the kicker.
Yeah. Yeah. You definitely have to. And the form is the AEA form, I believe. The addendum. I'll show it to you right now. But yes, if you provide all of the disclosures and the buyer has released physical inspections and now you realize, oh shoot, I forgot to add this and you're still in escrow. Yeah, you add this form explaining what this new material issue that you're providing, and the buyer receives it. And the buyer has 5 additional days to do an inspection, review it, and they can also negotiate, because this is something new that they were not aware and they released that as a condition. Yeah, they can come back and try to negotiate. And if we cannot come to terms, the buyer has the right to cancel. And the buyer has the right, if after even releasing all contingency, folks, and that's the kicker. Okay, that unfortunately, because this was a new material fact that was not disclosed prior, the buyer may have the right to back out of the deal and retain their full deposit back. So be very, very careful with that. And it happens. Hey, it happens. Okay. And you want to work with the buyer on this, right? You may have to bend a little bit because we make the mistake of not providing that disclosure or issue. Or even like I get this, we're in escrow and then there's a plumbing issue. We came back from vacation and the whole house flooded, right? And we got the insurance, we got it taken care of, but that's a material fact that we have to provide to the buyer, even if we're in escrow. So back to your questions, yes. Boundaries, landscaping, pool and spa, condominiums and common interest development. Okay, this is a lot of people get a little stuck on this too as well. Title insurance, ownership, liens, and legal claims. Okay, here's another one too. Other than the seller signing the form, any other person or entity with an ownership interest. Lease options or claims affecting or relating title. Past, present, pending, or threatened lawsuits. Okay, that's another one. Let me ask you. Okay, it doesn't give you a specific timeline, but let's say you had a pet. And that pet was a puppy, grew up, matured, and now the mailman or mail woman comes in, or the mail carrier, I should say. I think that's the right way to say it. The mail carrier comes into the property to deliver the mail. Dog's there, bites the mail carrier, and now the mail carrier sues the homeowner for pain and suffering, right? And is asking $50,000. The homeowner's insurance kicks in, they negotiate, they come to an agreement, and ultimately settle at $15,000. Okay. That's on the record, right? Is that considered, even though this happened 2-3 years ago, 5 years ago, is this something that you must disclose?
Yes.
Yes.
Absolutely. Yep. Something you have to disclose. Okay, even fences too. There's also issues with fences. I see that quite often with disputes regarding neighbors and fences and encroachments, right? If you know there's an encroachment and you fail to disclose, the buyer can come back and says, well, I thought I was buying 7,000 lot size, but I'm only getting 6,500. I'm losing and I'm paying taxes. I'm going to sue the previous seller. And that can happen. That can happen. So be very careful. If you know there's an encroachment, all right, divulge and disclose and let the buyer make a sound decision in how they want to navigate that. Okay. Because ultimately, I'd rather fully disclose than fail to disclose and it comes back to haunt us, okay? I don't want to be dragged into, I want to focus on new business.
But it's gonna be rare that we as agents and even our sellers will have actual knowledge of a boundary dispute without actually having a formal survey in hand, just so
That's right.
we're aware.
That's right. When in doubt, disclose. Yeah, Robert says, just to clarify, if the seller asks if the SBQ is required, it's not required by law, but by the RP8. Okay? No, it is a requirement. It's an addition to the TDS. So in essence, Robert, if a seller is selling a property and they're still alive, this is incorporated with the TDS. So the TDS is the number one that must be provided, and this is the additional to the TDS. Okay, I don't necessarily know if it's law, but again, the way I see it is, if it's relevant about the condition of the property, it should be part of the and it's part of our compliance as well, you know. And this is why we have a compliance department that if we don't see it, that immediately we start asking questions. So ours too, my parents too, I'm not sure what that means. Gov Hutchinson said some condo associations have not done balcony inspections per law, and some lenders are refusing to fund until the inspection is done. Yeah, 100%. Yeah, that definitely is an issue. And it definitely, we see that quite often. 1 second. Okay. Let's continue. Neighbors. All right, nuisance. All right, so let's say that you are selling the property because your neighbor has a barking dog or animals, and they start partying and not finish till like 3 or 4 in the morning, and it's a consistent issue. It has nothing to do with the property. Okay? But it's your neighbor or your neighbor's two doors down. Is that something that we must disclose? 100%.
Yes.
Yeah, 100%. Because again, the buyer's gonna go in there thinking it's quiet during the week. They move in on the weekend, first weekend that they're in there, they're partying it up till 4 in the morning, and this individual that bought it has to get up super early, so they gotta sleep in early. That's an issue. That could be a problem. That can open up a can of worms. Yeah, so yeah, so be very, very careful, folks. That if the and that's something that you should have as part of your little checklist. Hey, you know, I know neighbors and all that can be sometimes very fun, very enjoyable to have. Sometimes we got great neighbors. You know, thank goodness, I've had some good experiences with my neighbors. Both of my neighbors are retired. Okay, so they're always home, and then when I get home and I'm driving into my driveway, it's like, now I'm gonna have to have a 20-30 minute conversation. Because he's out there watering his grass, which is okay. My previous neighbor too, he worked at home, and then he finally retired, and he ended up getting a little dog, and that was his pride and joy. But I would try to, you know, I'm a person that loves to talk to people, but man, oh man, I mean, they just spill it all out, and there was one time that I spent almost 2 hours talking to my neighbor, and I just didn't know how to politely say, I gotta go, but then I got better.
Garage with direct access.
There you go. There you go.
Mr. Social.
There you go. Exactly. All right. So again, just part of the process. You know, we have to navigate this.
But
Okay.
the neighborhood noise is everything. It could be traffic noise, it
Yeah.
could be airplane noise, it could be neighbor noise, it could be, you know, even fumes from a business that the breeze blows in that direction.
Right.
You know, you know, everything under the what about question, well, what about this, what about, if in doubt, disclose.
Yes, sir. Yep, 100%. All right, governmental stuff, you know, zoning and all that fun stuff. Yeah, you know, if you live next to a high school, trains, okay, I own the property that is not next to, but 5 houses to the train. That's something that, you know, it's obviously visible, right? I can see it, but I'm still going to disclose it as well.
I still disclose when it's a half mile and they blow, and you can hear the horn when they blow
Yeah.
the horn at night.
Yeah,
And so,
100%. Thank you.
yeah,
Yeah, the flight path, LAX, you got properties, South Central area. And the flight path, you can literally see the plane and you can smell the jet fuel. You know, that's, again, I would disclose stuff like that. Property that I bought, funniest thing, the seller, who didn't even, was an absentee seller, lived in Colorado. When I looked at the disclosures, he says, hey, you got animals that foster and roam the property. And he was very specific. Peacocks are one of them, skunks are another, and those damn raccoons, man. And I see it now. They literally, I see the water, the hose from the pool, the vacuum hose out of the water. It's like, what? I don't remember doing that. I look at my surveillance cameras, these darn raccoons will go in there and pull the hose out of the water. And one of them, darn it, was swimming like it's its own, their own little, they swim, the raccoons. I was like, I cannot make that up. But again, yeah, it is funny in my surveillance. It's like, man, oh man, these are funny. I mean, and then I have peacocks that are on the garage. One actually sleeps on the chimney every night at 8 o'clock in the evening, 8:30. He's up there already calling it a night. But again, as an example, if I was to sell that property, that's going to be part of my disclosures, right? Just saying. Okay. All right. I think you get the understanding, right, of the SPQ. All right, material facts, any past, present, known material facts, or any significant items affecting the value and desirability of the property not otherwise disclosed. Okay, and then you have where you can add additional comments. Seller signs, the buyer confirms after, and it says buyer acknowledges that the buyer has read, understood, and has received a copy. And that is your SPQ. Okay. All right, real quick, and I apologize. I know I'm going a little over my time, but I think it's really relevant. Just wanted to share the TDS because I think these are the two most important documents that we have to provide.
the TDS was the original disclosure form that came out.
Yes.
And the SPQ, I call it the dragnet. That was the second one that came out. Anything that wasn't covered on the TDS is now covered in the SPQ.
That's right. That's right. All right. So the real estate transfer disclosure. Okay. So this is the one that's the comprehensive one that is not as thorough as the SPQ, but this one has a lot of line items that, you know, must be kind of in writing. All right. So real quick, it goes into the statement is a disclosure of condition of the above described property in compliance with the Civil Code 1102. It is not a warranty of any kind of by the seller or the agent representing any principal in the transaction, and it's not a substitute for any inspections or warranties that the principal may wish to obtain. So full disclosures, remember the buyer can do anything they want in regards to inspections, right? General home inspections, plumbing, roofing, electrical, whatever they need to do, they must have the right to do so. These are just additional documentation from the seller explaining this is what I know from my perspective on the condition of the property or anything that should be relevant. All right. So it goes into if the seller has any additional inspections or reports completed. So sometimes the sellers may do pre-inspection And if it's done and you have a copy of it, the seller has a copy, then unfortunately that's considered material fact. You must click that and provide that as part of the seller disclosures, okay? Any additional inspections, you can write it here. No substitute disclosure for this transfer. And then it says the following, the seller discloses the following information with the knowledge that even though this is not a warranty, because none of this is a warranty, remember, all properties are sold in as is condition. The following is a representation made by the seller. So the property has the items checked, okay? Is one, the seller occupying the property or not occupying? So either they are or not. A goes into what is included with the property. Be very careful because I've seen arguments where the seller accidentally put something and it doesn't have it, like a refrigerator. And now the buyer is saying, well, you disclose that. What was it was an accident, right? We didn't, they can go heavy and deep into it. And now you're in a position is like, do you want the headaches? You may just have to cough up a money to provide that refrigerator. So be very careful. So once the seller completes this, go over with the seller and says, okay, just so we're both on the same page, you check out that the property has and will stay with the property, the dishwasher, the trash compactor, the garbage disposal, rain gutters, burglar alarms, carbon monoxide, all that, right? So that way you're both on the same page. Okay. Section 2, down here it says, is there any, to the best of the seller's knowledge, any of the above that are not in operating condition? So if it is yes, you must disclose that information. Okay, and you can add additional, and this has a, what do they call it? A supplement. So yeah, thank you. That you can put all of the information and it'll include an additional form with it.
If you want to sweeten the deal and say, hey, the house has a garage, but there's also a car in the garage and I'll give you the whole house and the car in the garage. Would you put this on the form as well? This is not you do that. You heard that before?
This is regarding the property.
Okay. Help yourself. Okay.
So if it's a car, I get it, and I've seen it where you may sell furniture as an example, right?
Sure. Put it in the counter.
Okay, you just put that as part of the counter.
Okay, gotcha.
Okay, this is only for the property condition. Okay, has nothing to do with the property, because remember, a car is not considered real property. It's not attached to the property, right? It's personal, so I would not put that as part of the self-disclosure. But good point. I mean, I know you're thinking of all these ideas here. But the next is, just kind of the standards of articles and, building codes, and all that, depending on where the property is located. If it's in the city of Los Angeles, they have city of Lawndale, has city inspection, city of Compton, so on and so forth. The next is kind of similar to the SPQ. Are you seller aware of any of the following? Make sure that they understand. Now, it also references here that section C4 and 5, if transfer will acquire the property within 18 months of acceptance of an offer to sell, shall make additional disclosures, and that goes into, again, the seller property questionnaire. And again, pretty self-explanatory that it talks, if it's relevant, it's something that you must disclose and you put it on there. If you answer yes to any of these questions, then you can add it here, and a supplement will pop up as well. Seller certifies the information here is truth, and then it goes into section 2, right? Or section 3, I should say. This is where the agent inspection disclosure to be completed only if the seller is represented by an agent in this transaction. The undersigned based above inquire of the seller as the condition of the property and is based on a reasonable, competent, and diligent visual inspection of the accessible area. So it goes into the information of the section that says if check, right? So you've got a couple of check marks here. Attach agent visual inspection, better known as the AVIT. You always want to check this. Agents know no items to be disclosed. I want to warn you about this, okay? Because I see a lot of agents that don't put anything, they'll check it because they just don't want to add anything else. Here it is. I'd rather be a diligent, proactive agent, and I'm not going to say nothing to be disclosed. There is always something to be disclosed, always. Find something, okay? I don't want you to make damage to anything and then says, oh, I did this, so I can just know. But you can find something to disclose, so please avoid from saying agent, no items to disclose, okay? Check number 3, agent notes the following items, right? Or you can also, because you're adding the avid, right, which is a visual inspection of the property, that's the reason you're going to go in that direction, okay? Then you put in the information, and that information is from, the seller, right? And then the next is the buyer's agent, okay? This is you as the buyer agent. You also have to be diligent in your position and provide, what you see on the overall. If you hear something or you see something, document it and put it in your section here as well. All right, you as an agent sign here, the listing agent signs up there, both the buyer and the seller sign, and that pretty much completes the TDS. Now, and I'll finish with this, guys, and I sincerely apologize for going over my time, but here it is. These are just 2 of more documentations that you must. Now, this is why it's important to have your TC involved so they can provide, like the NHD report, the AD form, the possible representation of more than one buyer. All of these are all relevant disclosures that both parties need to sign and execute and transfer. I'm just giving you the meat and potato of the most relevant documentations that you'll come across on a regular basis when selling real estate, okay? These are, again, I get this question often about what if the property is more than 4 units? Then no, this is only for single, duplex, triplex, fourplex, condos, condominiums, and there's manufactured, but the manufacturer disclosure is different. It is a TDS, but it's called manufacturer transfer disclosure statement. So make sure you know which document are you providing the seller to fill out and the buyer to fill out. With that, any final questions before we close out? No questions. Okay, I just saw a video of many animals jumping on a, that's funny, at night and a bear dog. Yeah, it happens. And I'll be the first to say, I've seen it in action in my own surveillance camera. All right, team. Well, that concludes our class. Thank you very, very much for hanging out. And if you have any questions, please don't hesitate to reach
Thank you,
out.
Simon.
Thank you, Simon. This was great as always.
Thank you.